Okay, we're live. We're reading about corporations from the CMR outline and California, this particularly. Um, First, going into formation of a contract, introduction, a corporation is a legal entity distinct from its owners and may be created only by filing certain documents with the state. Key players, there are several key players we need to remember in the context of corporations. Those are shareholders, board of directors, and officers. Shareholders or stockholders are the owners of the corporation. The board of directors is a group in charge of management of the corporation, and officers are agents of the corporation appointed to carry out the corporation's policy. Key characteristics: limited liability for owners, directors, and officers. The shareholders generally are not personally liable for the obligations of the corporation, neither are the corporation's directors or officers. Generally, only the corporation itself can be held liable for corporate obligations. The owners risk only the investment they make in the business to purchase their ownership interest or the shares. Centralized management. Generally, the right to manage a corporation is not spread out among the shareholders, but rather centralized in a board of directors who usually delegate day-to-day management duties to officers. Free transferability of ownership. Generally, ownership of a corporation is freely transferable. That is, generally shareholders are free to sell their shares unless it is provided otherwise. Continuity of life. A corporation may exist perpetually and generally is not affected by changes in ownership, that is, sale of shares. Taxation. Corporation. Generally, a corporation is taxed as an entity distinct from its owners. Under the tax laws, it is a C corporation. The corporate tax rate generally is lower than the personal tax rate. And so this arrangement can be advantageous to persons who want to delay the realization of income. However, this advantage comes at a price: double taxation, because when the corporation does make distributions to shareholders, the distributions are treated as taxable income to the shareholders, even though the corporation has already paid taxes on its profits. S corp. The tax laws permit certain corporations to elect to be taxed like partnerships and yet retain the other advantages of the corporate form. See above. Such corporations are called S corps. Under the tax laws, these are discussed in further detail in the module below. Comparison versus other business entities. Comparison with the sole prop, comparison with the partnership, comparison with the limited partnership, comparison with the limited liability, and comparison with benefit corporations. So in a sole prop, one person owns all of the shares of the business. There is no business entity distinct from the owner. The owner is personally liable for the business obligations, and the business entity cannot continue beyond the life of the owner. Ownership is freely transferable, and all profits and losses from the business flow directly to the owner. Comparison with partnership. A partnership is similar to the sole proprietorship, except that there are at least two owners of the partnership. Little formality is required to form a partnership, just intention to carry on as co-owners of business for profit. And partnerships generally are not treated as legal entities apart from their owners. Partners are personally liable for obligations of the partnership. The management rights generally are spread among the partners. Ownership interests of partners cannot be transferred without the consent of other partners. A partnership generally does not continue beyond the lives of its owners. Finally, profits and losses of a partnership flow through directly to the partners unless the partners have elected to be taxed as corporations. Comparison with limited partnerships. A limited partnership that provides for limited liability to some investors is called limited partners, but otherwise is similar to other partnerships. A limited partnership can be formed only by compliance with the limited partnership statute. There must be at least one partner who has full personal liability for partnership debts and has most management rights. Comparison with limited liability companies. A limited liability company is designated to offer the limited liability of a corporation and the flow-through tax advantages of a partnership unless the parties elect to be taxed as a corporation. Like a corporation may be formed only by filing appropriate documents with the state, but otherwise is very flexible business from Owners may choose between centralized management and owner-managed free transferability of ownership to restrict transferability, etc. Comparison with the benefit corporation. A benefit corporation, B corporation, intends to benefit the public and environment in addition to its shareholders. B corporations are treated the same as C corporations for tax purposes. A benefit corporation articles of incorporation must state that it is a benefit corporation. Directors and officers of benefit corporations operate with the same limited liability and fiduciary duties as their traditional counterparts in C corps. But they are also required to consider the impact of their decisions on B corporations' employees, customers, communities, and the environment, not just as shareholders. B corporations must also prepare an annual benefit report, which is delivered to all the shareholders and posted online and or filed with the Secretary of State. I've literally never heard of this term before in my life. How do you distinguish it from a corporation? It intends to benefit the public and the environment. Don't give us an example or anything. I feel like it's the Times Corporation. I'm kidding. But from their case, like, anyway. Constitutional characteristics of a corporation: person, citizen, resident, domicile. A corporation is a person entitled to due process, equal protection, and attorney-client privilege, but not to the Fifth Amendment privileges against self-incrimination. Citizen: a corporation is not a citizen for purposes of the Privileges and Immunities Clause for federal diversity jurisdiction purposes. A corporation is a citizen of any state of incorporation and the state of its principal place of business. Usually is its headquarters. So again, a corporation is a person. They're not a citizen, not entitled to privilege and immunities, which I looked at just a moment ago in con law. Resident, they're a resident where they're incorporated, where they're doing business. And for domicile, their domiciliary is the state in which they're incorporated. But resident can be where they're doing the principal place of business. 6 fact patterns. On the exam, corporations questions generally can be organized into 6 fact patterns: organization of the corporation, issuance of stock, directors and officers, shareholders, fundamental corporate changes, and federal securities. What does it take to form a corporation? People, Paper, Act. Corporations are created by complying with the state corporate law, which in a majority of states is based on the revised Model Business Corporations Act. A corporation forms with the law is de jure corporation. If all corporate laws have not been followed, a de facto corporation might result, or a corporation might be recognized through estoppel. To form a corporation, we need a person, paper, and an act. People, incorporators. To form a corporation, we need one or more persons who undertake to form it, who are known as the incorporators. What does an incorporator do? They execute, sign the articles, and deliver them to the Secretary of State. The incorporators must comply with all applicable statutory requirements to form the corporation. Incorporators may be a person or an entity. They do not need to be the citizen of a state or incorporation. Paper articles of incorporation. To form a corporation, we also need a particular paper, the articles of incorporation. The articles are a contract between the corporation and the state. Required contents and articles. Articles of incorporation must include the name of the corporation. A corporation's name must be one of the following words: corporation, company, incorporated, limited. That's got to be in the name. the name and address of each incorporator. This is to be filed with the Secretary of State. The name of the registered agent and the street address of the registered office. The registered office must be in the state. The registered agent and the company's legal representative, meaning that they could, for example, receive service or process for the corporation. Information regarding the corporation stock discussed in further detail below. Duration. Know that there is no statement duration in the articles. We presume perpetual existence. In other words, the corporation can last forever. Statement of purpose. Traditionally, corporations have included a statement of business purpose in their articles. Absence of statement, the NBCA presumes that a corporation is formed to conduct any lawful business, meaning the articles need not include such a statement and is allowed to undertake any act that is necessary or convenient for carrying on their business purpose, including making charitable donations and lending money to employees, officers, or actors. Ultra vires. If a corporation includes a narrow business purpose in its articles, it may not undertake activities unrelated to achieving its stated business purpose. An ultra vires activity is one that's beyond the scope of the articles in the hypo above. Note that we have a specific statement of purpose rather than a general one. At common law, any ultra vires contract will be voided as beyond the company's capacity. Today, under the NBCA, the ultra vires contracts are valid. We don't void them, and so these facts generally are enforceable. The ultra vires nature of an act can be raised only in these three circumstances. Situations. A shareholder may sue the corporation to enjoin a proposed ultra vires act. The corporation may sue an officer or director for damages for approving an ultra vires act, and the state may bring an action to dissolve a corporation for committing an ultra vires act. I'm not going to elaborate. Capital structure stock. As noted, the articles must also include information about the corporation's stock. It's important to remember some key definitions in relation to stock, which are: authorized stock is the maximum number of shares the corporation can sell. Issued stock is the number of shares the corporation actually sold. Outstanding stock is the shares that have been issued and not reacquired. The articles must include 1, the authorized stock; 2, if a company has different classes of stock or series within a class of stock, the number of shares per class, and a distinguishing designation for each class. For example, Class A preferred, Class B preferred, and so on. 3, information on the voting rights, preferences, and limitations for each class of stock. Options contracts. The articles may also include any other provisions regarding operation of the corporation that is not inconsistent with the law. For example, the articles very commonly include the names and addresses of the initial directors. Articles may also require that any internal corporate claims be brought exclusively at the court within the corporation state of incorporation. The articles may limit or eliminate directors. I thought this got brighter. Directors what? Directors' personal liability for money damages to the corporation or shareholders for actions taken or for failure to take action. However, the articles may not be limit or eliminate liability for financial transactions received by the director to which she is not entitled and intentionally inflicted harm on the corporation or its shareholders, unlawful corporate distributions, or an intentional violation of law. The light is crazy. Okay, act. To complete formation, the corporation or the incorporators will have notarized articles delivered to the state Secretary of State and pay required fees. What happens if the Secretary of the State's office accepts the articles for filing? That's conclusive proof of valid formation. Corporate existence begins upon the filing of the state. At that point, we will have de jure corporation. Then the board of directors holds the organizational meeting where it selects officers and adopts any bylaws and conducts other appropriate business. Legal significance of formation of corporation. Now that we've formed a corporation with a person, a paper, and an act, why does it matter? Let's look at several important consequences that follow from formation. Significance of formation of corporation. All right. Why does it matter? Internal affairs doctrine. Under the internal affairs doctrine, the internal affairs, for example, the roles and duties of directors, officers, and shareholders of a corporation are governed by the law of the state of incorporation. Entity status. A corporation is a separate legal person. It can sue and be sued, hold property, be the partner in a partnership, make charitable contributions, etc. It is taxed on its profits. In addition, shareholders are taxed on distributions, so there is double taxation, which is a disadvantage. As noted above, a corporation qualifies as an S corp to avoid having pay income twice. To do so, the corporation must meet the following requirements. They must have no more than 100 shareholders, all of whom are U.S. citizens or residents. They must have one class of stock, and they must not be publicly traded. Limited liability. One of the most important consequences of forming a corporation is the limited liability. Directors, officers, and shareholders are not liable for what the entity does. This is a limited liability, which means that shareholders generally can only lose the amount which they've invested in the company. So generally, who is liable for what the corporation does? The corporation itself. That is why we incorporate so that owners are not personally liable, except they are. Maybe officers are, not directors. No, directors and officers are. Corporate shareholders aren't. Now we're in Module 2, other formation issues. De facto corporation and corporation by estoppel. One of the main reasons to incorporate is to avoid personal liability for obligations that the corporation incurs. If the incorporators thought that they formed a corporation, but they failed to do so, they may be personally liable for business debts. Basically, the would-be incorporators have formed a partnership instead, and the partners are liable for business debts. But two doctrines, one, the de facto corporation and the corporation by estoppel doctrines, may still allow incorporators to escape liability. Under these doctrines, the business is treated as a corporation, so incorporators are not liable for what the business did. One important characteristic of both of these doctrines is that anyone asserting them must be unaware of the failure to form a de jure corporation. De facto corporation. Characteristics and requirements for a de facto corporation to exist. We must meet the following requirements. There must be relevant incorporation statutes. On the exam, you can address this requirement quickly. It will always be met because there's an incorporation statute in every state. The parties made a good faith, colorable attempt to comply with the statute, meaning the parties tried, came close to forming a corporation, and there has been some exercise of corporate privilege, meaning the parties were acting as though they thought they were a corporation. All right. If the de facto corporations doctrine applies, the business is treated as a corporation for all purposes except an action by the state called quo warranto action. Limitation. It's important to remember that the de facto doctrine can be raised as a defense to personal liability only by a person who is unaware that there was no valid incorporation. Persons who act on behalf of a corporation knowing that there was no incorporation jointly and severally liable for the liabilities created in so acting. Corporation by estoppel. Under the common law doctrine, the corporation by estoppel persons who have dealt with the entity as if they were a corporation will be stopped from denying the corporation's existence. The doctrine applies to contract to prevent the corporate entity and the parties who have dealt with the entity as if they were a corporation from backing out their contracts. Correspondingly, it will prevent the improperly formed corporation from avoiding liability by saying it was not properly formed. Note well that corporation by estoppel applies only in contract cases. It doesn't apply to tort victims because doctrines is based on the notion that third parties accept the risk of dealing with the corporation. That is the case with contract, but not in tort. Application of doctrines. Generally, if the de facto doctrine is found, it is treated like any other corporation for all purposes, except that the state may seek dissolution in a quo warranto proceeding. Estoppel applies only on a case-by-case basis, while estoppel, as mentioned, generally is applied only in contract cases. The de facto doctrine applies equally in contract and tort situations. If there is no valid incorporation, the facts do not support a de facto or estoppel argument, generally the courts will hold only the active business members personally liable, and their liability is joint and several. So a corporation status, de jure, de facto, estoppel. If it's de jure, it's followed all statutory provisions. If it's de facto, there's colorful compliance with most statutory provisions and the exercise of corporate privileges. If it's corporation by estoppel, parties act as there. If there is a corporation, no requirement of following statutory provisions. And probably the under that line in this chart, what it's going to tell me is what does that mean? What's the implication? The effect on personal liability is that a de jure corporation insulates against the personal liability of its shareholders. A de facto corporation insulates against personal liability of shareholders, but corporation subject to quo warranto proceeding by state. And a corporation by estoppel insulates against personal liability in contract, but not in tort. Status of doctrines. What's that mean? Okay. These doctrines are abolished in many states. However, in one or both of the doctrines, if one of both of the doctrines is relevant to an essay, you should still raise them in your answer with this caveat, meaning the doctrine likely doesn't apply, but if it does, here's how it would work. Bylaws. Bylaws are an internal document. You can think of them as a corporation's operating manual. Corporations are not required to have bylaws, but we usually have them for internal governance matters such as setting record dates, for determining when who may vote at shareholder meetings, responsibilities of officers, times and places for regular meetings of the board, and methods of giving notice. Bylaws may contain any provisions for managing the corporation that is not inconsistent with the articles of law. The bylaws are not filed with the state. Remember, their internal articles are filed with the state. The board of directors, in some states, what does that say? The board of directors in some states or the shareholders can amend and repeal the bylaws of a corporation or adopt new ones. If the bylaws and the articles of corporation conflict, the articles control because they are the contract with the state and because statute says so. Pre-incorporation, most of the time. Pre-incorporation contracts. A promoter is a person acting on behalf of the corporation, not yet formed. Before a corporation is formed, promoters procure commitments for capital and other instrumentalities that will be used by the corporation after its formation. In doing so, they may enter into a contract on behalf of the corporation not yet formed. Promoters' relationship to each other. Absent an agreement to the contrary, promoters are joint venture partners or have a fiduciary relationship with each other. They will breach their fiduciary duty if they secretly pursue personal gain at the expense of their fellow promoters. Promoter's relationship with the corporation. A promoter's fiduciary duty to the corporation is one of fair disclosure and good faith. Breach of fiduciary duty arising from sales to the corporation. A promoter who profits by selling property to the corporation may be liable for his profit unless the material facts of the transaction were disclosed. If the transaction is disclosed to an independent board of directors and approved, the promoter has met his duty and will not be liable for his profits. If the board is not completely independent, the promoter will not be liable for his profits if the subscribers knew of the transaction at the time they subscribed and unanimously ratified the transaction after full disclosure. Disclosure must be to all who were contemplated to be part of the initial financing scheme. If the promoters purchase all the stock and subsequently sell their individual shares to outsiders, the promoters cannot be held liable for the profits of the sale or property of the corporation. Fraud. Promoters may always be liable if plaintiffs can show that they were damaged by their promoters' fraudulent misrepresentations or fraudulent failure to disclose all material facts. State or federal securities law. Many states have enacted securities laws known as blue sky laws, similar to the federal securities laws. However, federal law preempts state regulation of securities except with regard to 1, penny stocks, generally stocks selling for less than $5, intrastate offerings exempt under 1933 Act. So that's the SEC Act of 1933. actions, which is not the same as the Securities Exchange Commission Act. Because both of those were retained, though, so they both exist. And so you got kind of like a grandfathering going on, I think. So let's just read that again. Intrastate offerings exempt under the 1933 Act. And third, actions against brokers for fraud. And fourth, notice filing requirements for stocks sold within the state. Okay, I'm losing my mind now if I don't look it up. 1933 Act, Securities Act of 1933, and then the Securities Exchange Act of 1933. First major law to regulate the U.S. stock market after the Great Depression. Okay, so then what happened? That was the Securities Act. Well, what was the Securities Exchange Act? Okay, so it's like the next year, right? Securities Exchange Act of 1934. So there you go. I'm not crazy. I know this stuff. Promoter's relationship with third parties, pre-incorporation agreements. A promoter may enter into contracts on behalf of the corporation not yet formed. Our key question is, who bears liability for these pre-incorporation contracts? Corporation's liability. Since the corporate entity does not exist prior to the incorporation, it is not bound on contracts entered into by the promoters in the corporate name prior to incorporation. The corporation may become liable only if it expressly or impliedly adopts the promoter's contract. Use the word, they're not using the word novation, but they can do this by novation. How can adoption happen? Express adoption, the board takes an action adopting the contract. We'll discuss board action further in Module 4. I can't wait. And implied adoption, corporation accepts the benefit of the contract. For example, in the hypo above, the corporation might have moved into the lease premises or started using the lease premises or paid for it. Promoter's liability. Under the NBCA, anyone who acts on behalf of the corporation knowing that it is not in existence is jointly and severally liable for the obligations incurred. Thus, if a promoter enters into the agreement with a third party on behalf of a planned but unformed corporation, the promoter is personally liable on the contract. The promoter's liability continues after the corporation is formed. Even if the corporation adopts the contract and benefits from it, the promoter will be released from liability only if there is an express or implied novation. That is an agreement among the three parties, the promoter, the corporation, and the other contracting party, to release the promoter from liability and substitute the corporation for the promoter in the contract. So, exception. Agreement expressly relieves promoter of liability. If an agreement expressly relieves the promoter of liability, there is no contract. Such an arrangement may be construed as a revocable offer to the proposed corporation, and the promoter has no rights or liabilities under the agreement. Promoter's right to reimbursement. A promoter who is held personally liable on pre-incorporation contract may have a right to reimbursement from the corporation to the extent of any benefits received from the corporation. Foreign corporations. Foreign corporations transacting business in a state must register and pay prescribed fees. Transacting business. Transacting business means the regular course of intrastate, not interstate business activity. So it doesn't include occasional or sporadic activity in this state, nor does it include simply owning property in this state. So, FYI, I'm in the foreign corporations section, which are foreign corporations transacting business in a state must register and pay prescribed fees. Transacting business, I just defined this as a regular course of intrastate business activity, not sporadic or occasional. And registering as a foreign corporation may not transact business with the state unless it has obtained a certificate of authority from the Secretary of State. A foreign corporation may not be denied a certificate of authority merely because the laws of its state of incorporation governing its organization and internal affairs differ from the host jurisdiction. A foreign corporation registered by getting a certificate of authority from a Secretary of State. The corporation has to provide information about its articles and prove good standing in its home state and must have a registered agent in the state and pay fees too. Failure to register. What happens if a foreign corporation transacts business without registering? It will incur a civil fine and a corporation will be unable to assert a claim in the state. But the foreign corporation can be sued and can defend the suit in the state. Note that a failure to obtain a certificate does not usually impair the validity of a contract or corporate act. Once the corporation registers and pays back fees and fines, it can then assert a claim here. Issuance of stock. This is module 3. I'm just checking in BARBRI. I believe I have to go to module 6. So I'm like halfway there. But I just want to double check. Not like I don't know. I just don't want to know. Maybe these aren't so bad. It's just the issuance of stock. And I'm skipping everything about debt securities, and even though there isn't much here. Yeah, I gotta go to module 6. To start and operate a corporation, we need money, capital. Weird. The corporation can either borrow the money or raise it as selling stock or both. Either way, the corporation will issue a security to the investor. Security is a fancy word for investment. Debt securities. When the corporation borrows money, it issues a debt security, which is usually called a bond. The bond is a promise the corporation will repay the loan with interest. If the note is unsecured by corporate assets, it may be called indenture. Holders of debt securities do not have an ownership interest in the corporation, as opposed to owners of equitable securities. Terminology. Debt obligations may be payable either to the holder of the bond, a bearer or coupon bond, or to the owner registered on the corporation's records, a registered bond. A debt obligation must also have special features. For example, it may provide that it is convertible into equity shares at the option of the holder, or it might provide that the corporation may redeem the obligation at a specified price before the obligation matures. Equity securities. When the investor buys an ownership interest in the corporation, it issues equity securities, which is stock. The investor holds shares of stock. Importantly, the money invested does not create a debt. Terminology. Remember that shares described in the corporation's articles of incorporation are authorized shares. Those shares that have not been sold are issued and outstanding, except they try to say that doesn't exist anymore. Oh, no, they try to say that treasury stock doesn't exist anymore. Shares that have been reacquired by the corporation through repurchase or redemption are authorized but unissued, aka treasury stock. These are sometimes referred to as treasury shares. Shares may be certificated, that is represented by a certificate, or uncertificated. Classification of shares. A corporation may choose to issue only one type of share, giving each shareholder an equal ownership right, in which case the shares are generally called common shares. Affirmatively, ownership rights may be varied if the articles provide that the corporation stock is divided into classes or series within a class. Recall that if the shares are to be divided into classes or series within a class, the articles must include information such as the number of shares of each class. Share options. A corporation may issue share options. An option is the right to purchase shares in the future under terms predetermined by the board of directors. Options may be offered in exchange for the type of consideration, including future services. I'm not going to say how that doesn't. That's fine. Subscriptions. Subscriptions are written offers to buy stock from a corporation. One issue may be whether such an offer may be revoked. Pre-incorporation subscription. Under the MBCA, pre-incorporation subscriptions are, page 20, irrevocable for 6 months unless otherwise provided in the terms of the subscription agreement. or unless all subscribers consent to revocation. Payment, unless otherwise provided. Payment is due upon demand of the board. Demands may not be made in a discriminatory manner. A subscriber who fails to pay may be penalized by sale of the shares or forfeiture of the subscription and any amounts paid on the subscription at the corporation's option. Post-incorporation subscription. Post-incorporation subscriptions are revocable until accepted by the corporation. In other words, the corporation and the subscriber are obligated under the subscription agreement when the board accepts the offer. Consideration. What must the corporation receive when it issues stock? Form of consideration. Under the NBCA, stock or an option to buy stock may be issued for any tangible or intangible property or benefit to the corporation. This includes money, cash or check, property, services already performed for the corporation or discharge of a debt. There's a split of authority over 2 additional forms, promissory notes to the corporation and future services to the corporation. In some states, these work as consideration. In others, they're prohibited. So using them results in unpaid stock, meaning it's treated as water stock. Explained below. Amount of consideration. Traditional view par. Par means minimum issuance price. Traditionally, stock could not be issued by a corporation for less than the stock's estimate or stated par value, and the consideration received for the par value stock had to be held in a certain amount containing at least an aggregate par value of the outstanding par value shares. The corporation can still receive more than the par value amount for the shares. Par means minimum issuance price. Traditionally, stocks could not be issued by a corporation for less than the stock's stated par value, and the issuance was here again. It says consideration received for the par value stock had to be held in a certain account containing at least the aggregate par value of the outstanding par value shares. Yeah, this is for accounting reasons. Because everything above that amount is like it's an equity account, and I was never too good with the names of equity accounts, but it's a special equity account. There's par, because that's a special account, but what's above par, it fluctuates a little bit. So, to be accounted for. But par is static, so there you go. It's on your book, so it'll never go below that. So on the bar exam, if you're given a par stock, watch for watered stock, which can occur when par value stock is issued for less than its par value, which I'm not even go there. NBCA approach. Board determines value. The NBCA generally has eliminated the concept of par and allows corporations to issue shares for whatever consideration the directors deem appropriate. Consideration received. This is a fallacy. And I don't really care. I don't know why I go into all this accounting stuff. I will read it. It's one last paragraph. Consideration received for the issuance of stock need not be placed in any special account. If the corporation issues stock in exchange for consideration other than cash, such as for property or past services, the board determines the value of the property for services. The board's valuation is inclusive if made in good faith. The stock is considered fully paid and non-assessable as soon as the corporation receives consideration for which the board authorizes issuance. Of course, a shareholder who fails to pay the full amount agreed upon may be held liable for sums remaining unpaid. We're kind of talking about like the founders of the company. These are the subscribers. They're like your venture capitalists, and they're like, here's $100,000. I want 100% of your, sorry, I want 100 shares or whatever. I want 100 shares. I don't. And it's these people that like provide startup capital. They can not just revoke that, which is why this is like a lot of this has been kind of strict. But eventually, we're going to probably talk about what being a regular, like plain vanilla shareholder is like, not like one of these pre-incorporation subscribers. Preemptive rights. Right to maintain percentage of ownership. A preemptive right is the right of an existing shareholder of common stock to maintain their percentage of ownership in the company by buying stock whenever there is a new issuance of stock for money, meaning cash or equivalents like a check. In some states, this new issuance includes the issuance of treasury stock, but in other states it doesn't. Right must be stated in articles. Under the NBCA, shareholders now have a preemptive right to purchase newly issued shares to maintain in their proportional ownership interest unless the articles of incorporation provide the right. So if the articles are silent on this issue, we do not have preemptive rights. Limitations. Even if the articles provide a preemptive right, shareholders generally have no preemptive right and shares issued one for consideration other than cash, for example, services of an employee, 2 within 6 months after incorporation, or 3 without voting rights but having a distribution preference. So we're finally in module 4, fact pattern 3, directors and officers. Directors, statutory requirements and the role. Statutory requirements: the directors are responsible for the management of the business and affairs of the corporation. Directors. Qualifications of directors: they must be adult natural persons, meaning they must be human beings with legal capacity. Absent a provision otherwise in the articles or bylaws, directors need not be shareholders in the corporation or residents of any particular state. Any qualifications for directors prescribed by the articles or bylaws must be reasonable and lawful. No qualification may limit the ability of a director to discharge their duties. Number: we must have one or more directors. The number can be set in the articles or bylaws, which may require as many directors as desired. Election. Initial directors are usually named in the articles. If not, they are elected by the incorporators at the organizational meeting. After that, the shareholders elect the directors. The directors are elected at each annual shareholders meeting, subject to contrary provisions in the article. Staggered board. The entire board is elected each year unless there is a staggered or classified board. Whether there is a staggered board is usually set in the articles. The staggered board is divided into halves or thirds, with 1/2 or 1/3 elected each year. For example, say there were 9 directors. Instead of electing all 9 each year, we could divide the board into 3 classes of 3 directors each, and they would serve 3-year terms, as an example. Most companies have staggered boards. Removal. Shareholders can remove directors before their terms expire. A director is removed if the votes cast in favor of removal exceed the votes cast against. Shareholders may remove a director with or without cause. In other words, shareholders hire and fire directors. In some states, if there is a staggered board, shareholders can remove a director only with cause. A director elected by cumulative voting, which we'll discuss in a later module, cannot be removed if the votes cast against removal would be sufficient to elect her if cumulatively voted at the election of directors. Similarly, a director elected by a voting group of shares may be removed only by that class. Vacancies. Vacancies on the board may arise, for example, when director resigns before their time is up. In instances, who selects the person who will serve as director for the rest of the term. Generally, the board or the shareholders will select the replacement. But if the shareholders created the vacancy by removing the director, the shareholders generally must select the replacement. Board action. Board must act as a group. The board of directors must act as a group. So, is an individual director an agent of the corporation? No, they're not. Individual directors have no authority to speak for the or bind the corporation. The directors must act as a group. Even if there is only one director, they may take an act only in one of the following ways. Unanimous agreement, in writing email is okay, and separate documents are also okay, and at a meeting which must satisfy the quorum and voting requirements discussed below. I can hardly wait. I feel like reading just the chart, because this section is ratification of defective corporate actions, board meetings, requiring notice, and here's this lovely table broken into half. The left half is shareholders, the right half is directors. When, where, notice requirements, proxy voting allowed. So shareholders can use proxies, directors cannot. notice requirements for the annual shareholder meeting. Notice requirements are that they can be by mail between 10 and 60 days before meeting, must include time and place. For special shareholder meetings, the notice requirements are that they can be by mail between 10 and 60 days before meeting. They must include time and place and purpose. Directors, on the other hand, don't need notices for regular directors' meetings. With special ones, they need 2 days' notice of date, time, and place of the meeting. Where these meetings can be held anywhere, across the board. And when, for the annual shareholder meeting, this is held as board of directors, but must be within earlier of 6 months after end of fiscal year and 15 months after prior annual meeting. For special shareholder meetings, as the board of directors directs, I missed that word, or at call of 1/10 of all shares of persons authorized in the articles of bylaws. Directors' meetings that are regular and special occur as the bylaws provide. So let's read what ratification was all about. Ratification of defective corporate actions. Directors, incorporators, and officers may ratify defective corporate actions, that is, actions that are void or voidable due to a failure of authorization, such as those taken in the absence of a requisite board resolution or shareholder approval. And to ratify such an action, the board of directors must state the action to be ratified and the nature of the failure of authorization, approve the ratification, and seek shareholder approval if necessary. Board meetings, types of meetings, notice. If there is a board meeting, the method for giving notice is usually set by the bylaws. Directors may act in regular special meetings. For regular meetings, notice is not required. For special meetings, at least 2 days written notice, time, date, place is required and need not state the purpose of the meeting. Failure to give a notice. Failure to give required notice means that whatever happened at the meeting is voidable and maybe even void unless the directors who are not notified waive the notice defect. They can do this, 1, in writing at any time, and 2, by attending the meeting without objecting at the outset of the meeting. Proxies, directors don't have them to enter voting agreements for how they will vote as directors. Any efforts to do so are void. They're against public policy because directors of the corporation, non-delegable fiduciary duties. Note that this is different from shareholders who can vote by proxy and enter into voting agreements, which are discussed in Module 8. Quorum. For any meeting of the board, we must have a quorum. A quorum is a majority of all shareholders unless the bylaws say otherwise, but a quorum can be no fewer than 1/3 of the board members. Without a quorum, the board cannot act. Approval of action. If a quorum is present at the meeting, passing a resolution, which is how the board takes action at a meeting, requires only a majority vote for those present. So if there are 9 directors, at least 5 directors must attend the meeting to constitute a quorum. If 5 directors attend, at least 3 must vote for a resolution for it to pass. Broken quorum. The quorum of the board can be lost, broken if believe once the quorum is no longer present, the board cannot take an act at that meeting. Note that this rule is different for shareholder voting, which is discussed in Module 8. Action by unanimous written consent. Remember that any action required to be taken by the directors at a formal meeting may be taken by unanimous consent in writing without a meeting. Role of directors. Generally, the board manages the business of a corporation, meaning it sets policies, supervises officers, declares distributions, determines when stock will be issued, recommends fundamental corporate changes to shareholders, and so on. Note that directors have no right to inspect the corporate books. So they do have a right. Okay, so I just totally put a not in there when it doesn't belong. So directors also have a right to inspect the corporate books. Board may create committees unless the articles or bylaws provide otherwise. The board may create 1 or more committees with 1 or more members and appoint members to the board of governors or serve on them. The committees may act for the board, but the board remains responsible for supervision in the committees. The board may also delegate authority to officers. Common ones or required ones are the audit committee, compliance committee, often compensation committee, and those are like pretty standard, but they can be for unlimited reasons. But those are pretty standard. Compensation, audit, committees, management committee. Committees cannot take certain actions. While a board can delegate actions to a committee cannot take the following actions: declare a distribution, fill a board vacancy, recommend a fundamental change to shareholders. Note, however, that the committee can recommend such actions as to the full board for its action. So they can recommend those types of actions to the full board. Directors' fiduciary duties are at Module 5. This is the second to last module. Duty of care, the standard. A director owes the corporation a duty of care. Directors have a duty to manage to the best of their ability. They must discharge their duties in good faith and with the care that a person in like position would exercise under similar circumstances. The burden is on the challenger plaintiff. Challenging the director's action has the burden of proving that the statutory standard above was not met. The two common scenarios are nonfeasance and misfeasance. On the exam, you'll typically see the duty of care come up in two ways. Nonfeasance occurs when a director basically does nothing, in other words, and misfeasance occurs when the board makes a decision that hurts the corporation. Here, in contrast to cases of nonfeasance, causation is clear. There is a business judgment rule. Directors who meet the standard will not be liable for corporate decisions that in hindsight turn out to be erroneous. Under the business judgment rule, a court will not second guess a business decision if, one, it was informed, two, is made in good faith, three, was made without conflicts of interest, and four, had a rational basis. So informed, made in good faith, without conflicts of interest, and had a rational basis. We expect that a person in a like position would do appropriate homework, and if they did so, they are not liable for bad results. Think of the business judgment rule as a presumption that when the board took an act, it did appropriate homework. That's why the burden is on the plaintiff to show the board did not do appropriate homework. The director is not a guarantor of success. Directors may rely on reports of other information. Corporate officers or employees whom the director reasonably believes to be reliable and competent, and legal counsel, accountants, or other persons as to matters the director reasonably believes are within such person's professional competence, and a committee of the board of which the director is not a member. The director reasonably believes that the committee merits confidence. Those are some examples on reports or other information the board member can rely on. Opinions, reports, statements, financial statements, for example, prepared and presented by those corporate officers and employees they believe are reliable and competent. Legal counsel, accountants, or other persons with professional competence in a committee they're not on. Duty of loyalty. The standard is that a director owes the corporation a duty of loyalty. They must act in good faith with a reasonable belief that what they do is in the corporation's best interest. The burden is on the defendant in duty of loyalty cases arising from a conflict of interest. The business judgment rule does not apply in a duty of loyalty case because it can never apply when the fiduciary has a conflict of interest. The duty of loyalty about conflicts such as the director attempted to put their own interest ahead of the corporation's interest. That is why the burden in these cases is on the defendant. Common scenarios is A, conflicting interest, transaction, self-dealing. Oh my God, this is so long. It's going to be long. B, competing ventures. C, corporate opportunity doctrine. D, common law, insider trading, special circumstances rule. So the only thing I'm really going to go into are one, self-dealing is pretty obvious. It's a transaction between the corporation on one side and one of its directors, and two, that director's close relative, or three, another business of the directors. Stands for upholding a conflict of interest transaction is that a majority of disinterested directors without a conflicting interest approved and actually it's the board by majority, and knowing all material facts when they approved, or a majority of votes cast by disinterested shareholders, not conflicted, knowing facts, and notice, a proper shareholder meeting with notice. There's another alternative. It's judged by circumstances at the time of the corporation entered into the transaction. It was fair to the corporation. I don't know who decides that. Or interested directors' presence at meeting irrelevant, and special quorum requirements for purposes of vote on conflicting interest transaction. At a directors' meeting, a quorum is a majority of at least 2 disinterested directors. Many states, though, interested directors count towards a quorum. Note that a shareholder meeting, a quorum consists of a majority of the votes entitled to be cast, not including shares owned or controlled directly or beneficially by the director with the conflicting interest, and factors to be considered in determining fairness. So, enjoining and setting aside are kind of the remedies. So what it says here is, despite the statute's absolute terms, a transaction approved by the board of shareholders might still be set aside if the party challenging the transaction can prove that it constitutes a waste of corporate assets. So even if the deal is approved by an appropriate group, remember on the exam to say that some courts also require showing of fairness. In determining whether a transaction is fair, courts look at factors such as adequacy of the consideration, corporate need to enter into the transaction, financial position of the corporation, and available alternatives. Remedies for improper conflicts of interest transactions, including joining the transaction, setting this aside, damages, or similar remedies. Directors may set their own compensation despite the apparent conflict of interest, unless the articles or bylaws provide otherwise. The board can set director compensation. However, it must be reasonable and in good faith. If it's excessive, the board is wasting corporate assets and breaching the duty of loyalty. Competing ventures. Directors may engage in unrelated businesses, but engaging directly competing businesses raises serious duty of loyalty problems. So that's all that's going to be said about that. But the next section is called the corporate opportunity doctrine. So the director's fiduciary duties prohibit them from diverting a business opportunity from their corporation to themselves without first giving their corporation the opportunity to act. This is a usurpation of a corporate opportunity. The corporation must have an interest or expectancy, meaning they are positioned to take advantage of this opportunity. Opportunity had to really arise. The opportunity taken by the insider had to be something that arose from their position of serving as a director. The company has an interest or expectancy in something the defendant found on company time or with company resources, or just by virtue of their position. Remember that a usurpation problem arises only if a director takes advantage of the business opportunity to which the corporation could have or had an interest or expectancy. The corporation's interest does not extend to every conceivable business opportunity, but neither are opportunities limited to those necessary to the corporation's current business. The closer the opportunity is to the corporation's line of business, the more likely a court will find it to be corporate opportunity. Lack of financial ability is not a defense. The corporation's lack of financial ability to take advantage of an opportunity probably is not a defense. The director should still present the opportunity to the corporation and allow it to decide whether it can take advantage of the opportunity, because they can raise capital pretty easily, more easily than a natural person, or apply for loans. Board generally decides. It is the board that must decide whether to accept an opportunity or reject it. Remedies. If a director usurps a corporate opportunity, the corporation can sue to recover under constructive trust theory. If they still own the property, they can be compelled to transfer to the corporation at a price they paid. If they sold the property at a profit, the corporation may recover the profit. So disgorgement. Common law, insider trading, special circumstances rule. A director has no common law duty to disclose all facts relevant to the securities transaction between the director and the other party of the transaction. However, courts have found a duty to disclose where a director knows of special circumstances, for example, an upcoming extraordinary dividend or a planned merger. Duty to disclose. The directors also have a duty to disclose material corporate information to other members of the board. loans. A corporation can make a loan to a director if it reasonably expected to benefit the corporation. Other state law basis of director liability. Determining director liability, directors may be liable to the corporation for ultra various acts, that is, making the company do things it has no power to do, in which case reasonable officers or directors are liable for the ultra various losses. Or like those types of contracts that they enter into for things that are outside of the business purpose. The third party has a right to like avoid that contract, and if they do, I'm thinking that the board of directors responsible for entering into that contract could be held accountable. Note that the Federal Sarbanes-Oxley Act, discussed further in Module 10, generally forbids loans to executives in large, publicly traded, registered corporations. It requires the board of such large corporations to establish an audit committee and oversee the work of a registered public accounting firm. Chief executive financial officers must certify the accuracy and completeness of financial reports. Which directors are liable? How do we know exactly which directors are liable for improper actions? A director is presumed to concur with board action unless their dissent or abstention is noted in writing in the corporate records. And writing means 1, in the minutes, 2, delivered in writing to the presiding officer at the meeting, or 3, written dissent to the corporation immediately after the meeting. So an oral dissent by itself is not effective. Note also that a director cannot dissent if they voted for resolution at the meeting. Exceptions. A director is not liable under the rule above if they were absent from the board meeting, for example, they were sick that day, in which case they're not liable for stuff that happened at the meeting they missed, and they relied in good faith on the information, including financial information presented by an officer, employer, and committee for which the relying director was not a member or professional they reasonably believed was competent. Remember, the reliance must be in good faith. This exception doesn't work if the director knew the person giving the information wasn't reliable. Personal liability of directors may be limited. The articles may limit or eliminate directors' personal liability for money damages to the corporation or shareholders for actions taken for the failure to take action. However, the articles may limit or eliminate liability of financial benefits received from the director to which she is not entitled, and intentionally inflicted harm on the corporation or its shareholders, unlawful corporate distributions, or an intentional violation of criminal law. Module 6. Officers and indemnification. Officers, power and status. Officers are agents of the corporation. Agency law determines authority and powers of officers. The corporation is the principal and the officer is the agent. Whether the officer can bind the corporation is determined by whether they have agency authority to do so, such as actual or apparent authority. So watch for a crossover with agency on the issue. Unauthorized actions may become binding on the corporation because of ratification, adoption, or estoppel. Corporation is liable for actions by its officers within the scope of their duty, even if their particular act in question was not specifically authorized. Roles. Traditionally, corporations are required to have a president, secretary, treasurer. Now the corporation need not have any particular officers, but it may have those specified or permitted by its bylaws. One officer may appoint an assistant officers if permitted in or by the bylaws. May one person simultaneously serve? Yes. Duties. Officers serve more than one office. Officers' general duties are determined by the bylaws or to the extent consistent with the bylaws by the board or an officer so authorized by the board. Officers owe the same duties of care and loyalty to the corporation as directors. So the one thing it didn't say here is that an officer can also be a director. Now, selection and removal of officers. Officers are selected and removed by the board, which also sets officer compensation. Despite any contractual term to the contrary, an officer has the power to resign at any time by delivering notice to the corporation, and the corporation has the power to remove an officer at any time with or without cause. If the resignation or removal is a breach of contract, the non-breaching party may have a right to damages, but note that mere appointment to office itself does not create any contractual right to remain in office. Indemnification of directors, officers, and employees. Categories of indemnification. Let's say someone is Okay, I don't really need to go into this. So there's either no indemnification or mandatory indemnification. Corporation cannot indemnify a director who is held liable to corporation or held to have received an improper benefit. Mandatory indemnification is you must indemnify a director or officer who is successful in defending and proceeding on the merits and otherwise against the officer or director for reasonable expenses incurred in presenting a defense. So category 3, permissive indemnification. A corporation may indemnify a director in situations not satisfying the two categories above. An example of this is the case against a director or officer settled. 1, if they act in good faith. 2, believe their conduct was in the best interest of the corporation when the conduct at issue was within the director's official capacity. And B, not opposed to the best interest of the corporation when the conduct at issue was conducted not unlawful in a criminal proceeding. And the standards are the same as the duty of loyalty. Who makes the determination? Officers generally may be indemnified to the same extent as the director. Court order indemnification, notwithstanding the above rules, a court in which a director or officer was sued may order indemnification if it is justified in view of all the circumstances. If the director or board was held liable, the corporation reimbursement is limited to costs and attorney fees. It cannot include the judgment. Limitations on liability. The articles can eliminate director and, in some cases, officer liability to the corporation for damages, but not for intentional misconduct, usurping corporate opportunities, unlawful distributions, or improper personal benefits. So these provisions can eliminate liability only for duty of care cases. States are still split as to whether exculpatory provisions in the articles apply to officers too. Advances, liability insurance, and agents and employees. The MCA does not limit the corporation's power to indemnify advance expenses to or maintain insurance on agents and employees. Advances, the corporation may advance expenses to a director defending an action as long as the director furnishes the corporation a statement that the director believes he met the appropriate standard of conduct and that he will repay the advance if he is later found to have not met that standard. Liability insurance may be taken out for directors and officers. It would, even if they would not have been entitled to indemnification under the above standards. So that's going to be the end of Module 6. Back for 7 through 10.